Buying property in Australia is exciting, but it can also be legally dangerous if you don't know what you are doing. Every year, buyers lose money, miss opportunities, or end up in disputes simply because they didn't understand the legal steps involved. In this video, we will break down the 10 biggest legal mistakes people make when purchasing real property in Australia, with real examples that show how things can go wrong and how you can avoid the same pitfalls. This is general information only, not legal advice, but it will give you a strong foundation to make safer decisions during your property journey. Let's get started. One of the most expensive mistakes buyers make is signing a contract, or worse, bidding at auction without having their finance properly approved by the bank. Why this is dangerous? Banks may value the property lower than the purchase price. Loan applications can be delayed or rejected, and buyers may need to pay penalties or lose their deposit if they cannot settle. For example, a buyer purchased a property for $1.15 million without full finance approval. When the bank valuation came in at $1.05 million, the bank reduced the loan amount by $100,000. The buyer didn't have the extra cash and defaulted. They lost their entire 10% deposit, $115,000 gone instantly. So never make an offer or bid at auction until you have finance approval in writing, a buffer for valuation shortfalls, and a clear legal understanding of your obligations if finance fails. People often try to save money by skipping inspection reports, but this decision can cost more than they ever expect. For houses, you need a building and pest inspection report. A couple bought a seemingly well-maintained home. 6 months later, the floors began sagging. A structural engineer later confirmed severe termite damage. Repair cost was $38,000. A 350 pest inspection report would have detected. For apartments, you need a Strata report. A buyer skipped the Strata report to avoid the $650 fee. They later discovered the building had an upcoming $22,000 special levy for that particular lot for cladding repairs and replacement of aluminum composite panels that are combustible. This was clearly recorded in prior Strata meeting minutes. Skipping due diligence exposes you to serious legal and financial risk. Many buyers fall in love with the property and forget to check the legal restrictions that affect what they can actually do with the land. Restrictions include zoning rules, development overlays, flood or bushfire risk, restrictive covenants, easements such as sewer lines or shared driveways, and heritage protection issues. For example, a family bought a home planning to extend the living area. After settlement, they discovered a restrictive covenant limiting any additions to the original footprint. Their $150,000 renovation plan was legally impossible. Another buyer found out too late that a proposed major road widening would take a corner of their land, which could have been clarified by the council if they made inquiries. Therefore, always review planning certificates, zoning maps, and title documents. They dictate what is legally allowed. Buying property involves more than just the purchase price and loan repayments. Owners often overlook ongoing and upfront costs. Those costs include stamp duty, foreign surcharge duty, land tax, council rates, strata levies, water and sewage access charges, utility connection fees, fire safety compliance, especially for commercial property, and commercial outgoings like insurance and repairs. A buyer purchased a small commercial unit in King's Cross, believing strata fees were about $1,800 per quarter. After settlement, a fire incident took place, and they learned they will have to spend another $100,000 to comply with the fire safety regulations if they would like to maintain the existing use of the property. They had to negotiate a payment plan to comply with the requirements by stages. Lesson to be learned is that outgoings and compliance costs can turn a profitable investment into a negative one. Always review the contract, disclosure statements, and outgoing schedule. Insurance isn't only for after settlement. In some Australian states, risk passes to the buyer on exchange of contracts, not on settlement. Many buyers don't realize this. Types of insurance to consider including building replacement insurance, landlord insurance, contents insurance, and title insurance. For example, a buyer later discovered the neighbor's retaining wall was encroaching on their land. They faced the legal costs and potential reconstructions, but title insurance, had they purchased it, would have covered the loss. Insurance is not optional. It is a part of your legal protection. In modern property purchases, financial contributions often come from business partners, siblings, parents, friends pooling funds, or private lenders. When relationships break down or circumstances change, disputes can arise. A man bought a property with financial help from his parents. No written agreement was prepared. When he later separated from his partner, the parent claimed she should be repaid her contribution. The partner argued it was a gift. A major family dispute followed, and the matter went to court. The legal principle is that without documentation, courts may apply equitable contribution or resulting trust principles, which may or may not align with your intention. So always document loans, gifts, beneficial interests, and ownership proportions. Lack of records often leads to litigation. New or renovated properties come with multiple types of warranties, but buyers often misunderstand what they cover. These include statutory builder warranties, structural defect warranties, minor defect rectification periods, and appliance manufacturer's warranties. For example, a buyer reported cracking and water leaks 18 months after settlement, believing the builder must have fixed everything for 6 years. However, only major structural defects are covered for that period. The minor issues had only 12 months defect liability period, which had already expired. Another buyer complained about a manufacturing oven, believing the developer was responsible. In reality, it was covered by the manufacturer's warranty, not the builder. So understand each warranty's scope, duration, and claims process. They are not interchangeable. Many buyers assume everything they see during the inspection stays with the property, but this is not legally true. Fixtures are items permanently attached to the property, and they are deemed to form a part of the property and will be transferred at settlement. For example, built-in wardrobes, fixed lighting, flooring, and range hood. Chattels are items not permanently fixed and are deemed to be removed by the vendor before settlement. Things like washing machines, portable air conditioners, outdoor furniture, and removable spa. The family expected the home to include the large outdoor spa and an expensive gas heater. On the day of settlement, both were gone. Legally, they were chattels, and the contract didn't specify they were included. The buyers learned a hard lesson. If it's not written in the contract, it doesn't stay. Many buyers don't realize that tax applies differently depending on how the property is earned or used. For investment properties, consider negative gearing rules, depreciation, capital gain tax, and land tax thresholds. For owner-occupiers, think about CGT main residence exemption, land tax exemptions, or surcharges. A buyer lived in their investment property for only 2 months before renting it out. When they sold years later, they expected full CGT exemption. Instead, they faced a complex partial exemption calculation, resulting in a significant tax bill. Another example is that a buyer of a new commercial unit didn't realize GST applied to the purchase because the vendor was registered and selling as a part of their enterprise. So tax planning must occur before signing, not after settlement. This is the most common mistake buyers make. Contracts may include unfair special conditions, severe penalty clauses, clauses shifting repair obligations, inaccurate or missing disclosure statements, hidden exclusions of key assets, incorrect boundary plans or easement information. For example, a buyer signed a contract believing the granite flat was council approved. The contract included a clause stating the buyer relies on their own inquiries. After settlement, council confirmed the granite flat was illegal. The buyer was forced to remove it, costing over $30,000. A proper legal review would have identified the issue instantly. So never sign a contract until a lawyer has reviewed the contract of sale, title search, planning certificates, sewer diagrams, strata documents, and vendor disclosures. This is the best legal protection a buyer can have. Lastly, lawyers may give some advice that you may never think of. For example, after settlement, you may wish to consider a will that will allow you to pass on the title to your heirs smoothly and avoid disputes among your family members. Since real estate purchase is such a big investment, you wish to consider everything beforehand. These are the 10 biggest legal mistakes people make when buying real estate in Australia. Let's quickly recap. Making offers without finance approval, skipping inspections or Strata reports, ignoring zoning, easements, and restrictions on development, underestimating government fees, compliance costs, and outgoings, forgetting insurance or misunderstanding risk transferred, failing to document contributions from family or business partners, confusing various types of warranties, not understanding fixtures versus chattels, ignoring tax consequences, and signing a contract without legal review. Avoiding these mistakes can save you thousands, protect your rights, and give you confidence in one of the biggest purchases of your life. Thanks for watching, and best of luck with your property journey. I will see you next time.